Good afternoon, everybody. I can see that you're all joining. A warm welcome to you today. We've got an interesting webinar to present. This is the second webinar in a series that IDR Law has been hosting in collaboration with Radcliffe Chambers. The focus is on supporting charity legacy officers and charities in commencing litigation, dealing with disputes. And if you saw the September webinar at the end of last month, that was focused on the preparation for court and all that happens pre-action. So that was a really comprehensive webinar, and we're here today to follow on from that, to focus on what happens when a case reaches the courtroom, what happens when we get to trial. Again, the focus today is really on charity litigation and supporting charity legacy officers and trustees in how to properly deal with these scenarios. So my name's Eleanor Stenson. I'm a partner at IDR Law, specialist in contentious trusts and estates. And we work very closely with the Institute of Legacy Management in relation to supporting legacy officers in disputes. There are many charities out there with in-house legal teams, but likewise there are not, and we're working hard to make sure that the support is there as informally as possible, and hopefully before you need it, so that you are ready to see those signs and those red flags that might be coming down the road. What I wanted to mention today, something which we're very excited about at IDR. This week we're launching a charity claim checker, which is a piece of software which is completely free to use, and it's going to be available via our IDR network for legacy officers to use for that sort of immediate assessment of claims coming in, and to give you a route through to us for informal no obligation discussions at the outset. The link to the IDR network will be on the final slide. So when those are circulated afterwards, you'll have access to that. As well, it will be on the ILM website. So it will be available on both. It's completely free to use, and it's completely free to subscribe to the IDR network as well. It takes a couple of minutes. It's a useful hub of information as well. This webinar, the September webinar, and next month's webinar in this series will also be available on the IDRN for viewing for any colleagues who've missed today. So it's a useful resource, and we have a special charities portal within the IDRN which just has resources available for charity legacy officers. So with that in mind, I want to introduce Thomas Dumont KC, who's joining me today from Radcliffe Chambers. Thomas, many of you will know well. You know, he has a lifetime of experience in this area, and it's a real treat to have him here today to talk to us about how we approach a trial, how we advise our charity clients, and how we prepare both legally, technically, and emotionally for what can be a very highly charged experience. So I will just press on with the first part of our discussion, which is how and why do some cases go to trial. If you did see the September webinar, you will have seen the discussion over the Charity Commission's guidance for charities commencing or intending to take part in litigation. There's some quite broad guidance there, but it's all very sensible and something which really should be considered in every case, even the ones which don't necessarily, or you aren't necessarily expecting to go to a contested trial. Essentially, the guidance is broad, but it requires transparent and careful decision making, which includes taking legal advice and specifically consideration of the economic impact on the charity taking into account the prospects of success or failure. It requires the charity trustees to look at whether or not the actions are proportionate, and whether or not the Charity Commission should be approached for consent or for advice on whether or not to proceed. In all cases, in all litigation, parties are required to explore avenues of alternative dispute resolution, and the same goes for charities. It's exceptionally important to explore all of those options before we commence contested litigation, and certainly even to the point of walking up the steps to the trial on that very last part of the dispute. The main consideration for charities in embarking on this process is making sure that those decisions and those considerations are transparent and justifiable. And that means being able to refer back to them, continually be reflecting on those decisions, particularly when it comes to, and we will come to this later, in some doom and gloom over the issue of costs and liability for those costs if things don't go the way the charity wanted them to. So, coming to that, it may seem crazy for any case to have to go to trial, but given the risks and given the extensive sort of planning and budgeting and work that needs to go into that process. But there are some very good reasons why a case may end up at trial. And here you'll see we're reflecting on a couple of them. First of all, a point of law, that there may be a truly excellent and sensible and proportionate reason why a charity needs to bring something to court. And secondly, there might be very complex cases requiring significant evidential input, which naturally lend themselves to a contested trial and judicial intervention rather than being something that is capable of settlement early on. So with this in mind, Tom, it would be great to hear from you as to how you advise charities at this point of a case, how you look at those considerations and making sure that the decisions being made by the charities are sensible ones, and how you determine whether something is right to pursue to a trial or not. And also the point about those other types of cases that might just have that complexity, which means that the inevitable occurs.
Yeah, Eleanor, you're absolutely right. The examples we got down there on the slide, Radcliffe was a case some years ago where, following an earlier decision, Reed Benham, the charity sector was losing really quite a lot of money each year because of the way the courts had interpreted residuary gifts. And that was something which the charity sector was terribly keen to put straight if it could. And through ILM, we did an awful lot of work to find the right case to fight. So we went through somewhere between about 10 and 15 cases, each charity with a case where that issue arose, pooled it pretty much. And we looked to see which one was the best one to fight. And we found Radcliffe. We fought that and we won it. We established that the early decision was actually very limited. It was wrong as a general decision, very, very limited in its application. And that enabled the charity sector to save an awful lot of money pretty much every year. It was interesting too, because that was the family appealed it. We did a deal with them on the appeal, which was quite a generous deal, but we were terribly keen to make sure that we held our decision, which was going to have so much positive value for the sector, and we did. Ireland Midson, Ireland Blue Cross, another case, and Moj, if you're out there, I'm sorry we keep on bringing up Ireland Midson. I know you'd rather we just forgot about it and chucked it into the past. But that was a 75 Act claim where once it got to the Supreme Court, the charities who were fighting it got a really good passage out of the Supreme Court saying that charities don't need to defend their legacies. They've got the legacies they were intended to have. They do a good job, rather changing some of the court's attitudes before that. And that was a really helpful pointer from the Supreme Court, which was a tremendous benefit to the charity sector. And that was part of the reason why the case had been fought. Of course, the other reason that case was fought was that, from my understanding, I mean, nobody's told me, but from my understanding, the charities had made a perfectly generous offer to the claimant, which when she got her £40,000 award in the first instance, she hadn't beaten. So there were some grim consequences for her, which provoked her into going on to the appeal, which, as we know, went to the Court of Appeal twice and Supreme Court once. But if you've made what is a good offer for cost protection point of view, and that offer is not accepted, well, you will probably find you are inevitably going to go to court and possibly even appeal beyond that. You mentioned also the other sorts of cases. I mean, for a case of fraud or forgery, the defendant will either head for the hills as soon as you issue your claim or start getting expert evidence on handwriting and so on. Dr. Audrey Giles, retired now, handwriting expert, took the view that if the person who benefited under the suspected will actually fought it all the way to court, then that could only be because they were honest and it wasn't a forgery. Not quite true, actually. Some of them do run it. But if you've got a forgery or fraud case, it'll either collapse very early or they'll have the nerve to take it all the way to court because there's so much turns on it and they are such scurrilous people. So that's a reason really why those sort of types of cases might have to go.
Yes, quite. And I think that, particularly with the sort of fraud, forgery cases, you can do everything that you are required to do. You can mediate, you can do all of the things that the court wants to see you doing. But dealing with particular personalities is the obstacle here. And it's something which is a huge red flag in any sort of case where you are dealing with dishonesty or potential dishonesty. There has to be borne in mind the fact that you can try as well as you might, but this will not do anything without judicial intervention. So it's something certainly for legacy officers where this is a factor in a case. Those early considerations with the board, those discussions about what this looks like with success or failure and budgeting for costs, really the emphasis ought to be on their lawyers saying to them, look, I can tell you how much it's going to cost to get to a mediation, but the chances are we're going to end up at the point of trial, and those costs will be significant. So it's a really important factor to consider. Now just turning on to more doom and gloom, difficulties for charities. I mean, that this is the point of today, really, just to highlight these issues, these red flags, these really damaging potentials that any legacy officer needs to be aware of on receiving a claim. We've talked about the guidance and the principles that need to be followed in deciding whether to embark on a claim. And obviously you referred to the Radcliffe case, where it was a strategic and considered step that was taken to decide that particular issue. But ultimately, there has to be an early conversation, and there has to be buy-in from the trustees. As I say, in terms of the lawyer's role, it's to advise on worst case scenarios. It's to provide those costs budgeting, and for prospects of success to be very clearly discussed and frankly considered. There are plenty of very good reasons why alternative dispute resolution, mediation, negotiation ought to be done anyway, even in those unusual circumstances of fraud, forgery and dishonesty. but also because the court looks to the conduct of the parties generally, particularly on costs. I've referred earlier to the risk of personal liability, but even if it's not personal liability for the trustees, if there is an adverse costs order, it is something that the charity needs to be mindful of and be prepared for, not least because the longer that litigation continues, the more costs that everybody has to incur, not just us, not just the other side, but other parties potentially. And if there is an adverse costs order, then it's not just your own costs, it's other parties as well. Even if there are good prospects of success, sometimes things don't go our way. And so with all those considerations and those that clever, detailed legal advice, even then it can still go the wrong way, which can mean that the outcome is not what is wanted. The difficulty for charities particularly is the issue of negative publicity. We've referred to that here, and we'll come to it later as well in some more detail, but it's a highly relevant factor, and it goes to the Charity Commission's guidance as well on making sure that supporters aren't marginalised by decisions being taken by the trustees and the spending of funds on litigation. So it is it's a worrisome prospect. It's something that should never be undertaken lightly. And really, as Tom was saying, it needs to be the right case if it's about a point of law. If it's a different type of case and something which the charity finds themselves involved in without, beyond their control, then early settlement ought to be considered, ADR, and minimising the costs incurred both for the charity and everybody else to try to bring it to an early conclusion.
Can I butt in there just quickly on that on costs? There were different sort of costs considerations, but in some cases will be all or nothing. That the charity either wins the estate or it loses because of a different will which cuts them out. And in those cases, it's going to have to fund the costs if it loses out of its own funds. Now we have budgeting. They will know what those costs are going to be, but you still need to be able to find about 80% of the cost budget within about 28 days of the judgment. So that's an imperative to know where you stand. On other cases, it may be that 75 Act claims, for instance, it may be that somebody's taking a slug out of your estate, so there will still be funds in the estate which can fund the litigation. Those aren't quite so serious, but you still need to know that you can realise those funds quickly enough from estate assets, and you may still have to fund any cost orders in the interim before you actually get the estate assets sold and pocketed.
Yes, quite, and the I suppose the added layer of any interim applications that are made throughout the course of proceedings, if there are cost orders associated with that, it can be an ongoing process trying to find funds. Obviously, not as impactful as a decision at the end of a full case, but it's absolutely something to consider. And I think, as you say, the budgeting point is really crucial. Now, lawyers are required to work with their clients to prepare a full paper budget, which is presented to the court and looked at and considered by both parties and also then subsequently by the judge at a special hearing. So it can allow for preparation for those costs, as you say, and that's a really key part of that initial discussion, getting the board to buy into this, looking at all the risks and all the sort of different outcomes, good or bad. So no, I totally agree. It's so very important to think these things through practically, not just legally. And with that in mind, is it too late to settle? We've got we're prepared, we're ready, we've got to court, we've got our bundles there, our nerves of steel are ready to do battle, but is there any scope for us to try to bring about a settlement? I mean, the answer is, of course, there is always scope to look at settlement. It can be made more difficult by the fact that so much has been incurred in costs by that point. Parties are often pretty well ready to fight the case and want to sometimes see their day in court and have their say. But equally, where there are real risks to be taken into account, there is always scope for a deal. And presumably, most cases have already discussed settlement at some point. There may have been a mediation, there may have been a negotiation between the lawyers. That may have already happened and failed, but that still doesn't mean that there isn't the scope for discussion. Equally, these factors that I've set out here just need to be borne in mind, even up to the point of walking up to the steps of the courtroom. I'd be really interested to know, in your experience, Tom, if you had one of these right by the steps of the court settlement.
I have. In fact, I was doing it for the RNIB some years ago. It was quite a few years ago, actually, because April Plant was the legacy officer of the RNIB who came to court with us. And she's been in practice as a barrister for 20 years, so it must have been a few years back. But she remember saying after that, I've heard of deals being done at the door of the court, but I didn't realise it was literally true. And it was. We were opening the door to get into court, into the courtroom itself. And the other side came across to us and said, "Look, would you take this?" Absolutely, bloody right, we would. No question. It was a very good deal, and we did it. But you're right. Nowadays, particularly when the costs are so huge, have got so huge. By the time you get to court, you reckon it's too late to settle it because the cost will be such a big slug, and everybody's taken up their entrenched positions, and they're effectively they're gambling on the roll of the dice. But it still is the roll of the dice. And sometimes when people get to court, obviously the charity holds its nerve, but the other side may suddenly think, oh my God, what happens if we lose? So there is sometimes just that little opportunity to crack the case on the first day. It generally thought that's the barristers doing their usual scam, that they run it to the very, very last minute, make sure they get their brief fee, then settle the case at the door of the court, and they're all off to lunch together for a slap-up lunch afterwards to celebrate. You may have your suspicions, but that's not quite the way it actually works. Perish the thought.
Perish the thought.
And there's always if you can avoid the adverse publicity going to court, that can be hugely attractive to a charity.
Absolutely, the value there is often, the monetary side of things you would expect has been prepared for and budgeted for and discussed at length, but the benefit of avoiding that publicity is really priceless. So I think that it's certainly a consideration, and I think whilst it will take particular types of parties and particular barristers and lawyers involved as well to really get something like that over the line, it is still possible, and that is a real comfort. It doesn't take away from the months and potentially years of sort of fraught litigation that you've had to go through to get to that point, but it does give you a nice clean edge, gives you certainty, and quite often. Sorry. So
I was going to say what you do need to prepare a little bit for that possibility, and that is just to think if a deal could be struck, what sort of structure would it take, and then what impact has that got? Is that actually something that could be done in practice? Are there going to be tax aspects to that which we need to consider? And need to make sure that they allow the thing to really pay for itself sometimes, if you get the tax right. But if somebody says, as you're about to go to court, will you accept this? It's a bit late to be scrabbling around for your tax acts to see what the impact of that is. So you've got to have a bit of a just to give that a bit of thought before you actually hit court, so you know that you can cope with it.
Yeah, absolutely, and it's something that is pertinent for charities, particularly in their ability to compromise cases in certain ways, and practically whether or not they are able to meet any terms of a settlement. So if property needs to be transferred or something, for example, it's important to know exactly where you stand with that. And I guess the hope would be that those sorts of discussions and narrowing of settlement positions would have taken place at some stage throughout the litigation, so you vaguely know where you'd like to get to, and hopefully it would just be a building on of that. But as you say, there are plenty of cases where that doesn't happen, and so yes, it would need to be considered very quickly, very thoroughly, and having things like that in mind will certainly help the deal get over the line before your 10 a.m. start. So all is not lost, even if you get to the door of the court, and settlement. It should always be considered over an adverse outcome. It would be good now to turn to practically and procedurally what things look like. We haven't managed to settle. We've walked through the door of the court. Nobody has approached us with some fantastic offer. So we're there. We've got to get on with it. What does the trial look like, Tom?
Well, first of all, I wear this thing, so you won't recognise me from the photograph. There'll be a whole lot of people with fluffy animals on their heads wandering around, and you have to work out which is yours. Don't go cozying up to the other side too quickly. In practical terms, how they work, the courts can be big and they can be surprisingly small. You can find yourself squeezing into quite a small court sometimes if you've been given a smallish one. And then you may find yourself really close to the other side, who will be very, very resentful of you. So be prepared for, to be glared at, and the odd muttered insult as you go in and out of court, and try not to rise that. It doesn't look good if the charity representative gets in a fight in court. We've gone too far there. Get back. Sorry. I'll tell you when to go for that one.
I'm sorry. Terrible.
Not at all. Disturbing. Trying to break my back. Yes.
Keeping you on your toes.
Absolutely. You're in court. What have you brought with you? That's an interesting thing to know. Court nowadays is paper heavy, so the paper that gets put before the court on almost any action will run to file after file after file, and it's impossible for everybody to have their own set of files in the court in paper terms. But you may well want to have it on your laptop so that when a page is referred to, you can go to that page and follow exactly what's going on. So set that up first. Always bring in with you, if you can, a notebook, because there will be bits of the case which you will want to note down. There will be bits of the case which resonate with you as the charity legislator has worked in it in a way perhaps differently from it resonates with some of the lawyers who've got a slightly different angle. So it's always useful to make a note of some of the things that have happened, either because you don't understand them perhaps, and you want to, or because they are going to have a really useful effect, you think, on your case, and you want to make sure that it's not missed. Note it down. Note also the time at which that comment was made, because that enables us to get back to it in the transcript. The likelihood is now, in the modern era, that the court will be transcribed, court hearing will be transcribed, so that about 5:30 on every day, you get a transcribed copy of exactly what's gone on at court. And then, so if you know what time the particular event occurred, you can focus on that and use it later on and into your legal team. It may be some particular piece of evidence which you think is particularly important. It may be some comment the judge makes which is either adverse or supportive of your charity. Good to get that down, because we may need that later. So you're in there. You've got your pen. You've got your notebook. I would have one of these too, a large post-it note, large set of post-it notes, because if you need to pass a message through your barrister, through the solicitor probably, that's the great thing to jot it down on. It won't get too long, as you might do if you did it on a larger piece of paper. It's not too small that you can't hardly put anything on it. It gets put on his desk next to where he or she are standing, and gives them a chance to glance at it and take it in. So bring those two with a pen. That's the stuff which you're probably going to need. Dress appropriately for court. I mean, it seems a ridiculous thing to say, doesn't it? But I had a client who was married to a rather outgoing Brazilian woman. And we all stand up as the judge comes in, and I'd like to turn around just to make sure that they've sat down again, because I was in court once when everybody stood up, the judge came in, and my clients were still standing and had to be told to sit down a bit later. So I turned around to check she and the client sat down, and she's taken off her jacket, and quite frankly, like she wasn't wearing anything at all. You don't really want to be supporting your charity by doing that if you can help it. So the judge come in, we've all stood up, we all sat down again, and the case starts. Each judge will have their own way of handling the case, so I can't tell you exactly how what's going to happen. It used to be that the opening of a case was dealt with at quite some length. You expanded on all your arguments, you told the judge what he was going to hear, set it all out for him. That's done in the skeleton arguments now, which you'll have had a chance to see before trial starts. And the judge really likes to get on to the witnesses. They really like to try and close down the opening submissions if they can, although there are some judges who may not have read into it quite as much as they would claim to have done. Keep an eye out for the judge. Most of them say, I've read all the papers. When the judge says, I've seen all the papers, you know that they may not actually have read them all. They've just seen them there, though couldn't face it. So some judges will like you to expand the submissions. You never quite know how long that's going to take, whether it's going to take ages. Don't be too worried at that stage if the judge seems to be really adverse to your case. They often test what's being said to them. They often press the barrister to see, what the strength of the case is. And it can seem sometimes when the case is being opened that you will be a long way from winning the case, because the judge seems to have a real downer on your side. Don't worry too much about that at that stage. Hopefully it'll get better. Hopefully once the case gets moving, he'll understand, or he'll give the other side just as tough a going over. So don't feel you've got to run out in horror in the first few minutes. So the judge then says, let's get the witnesses into the box. And the witnesses are then yanked out from the back of the court, sweating, and they are led into the witness box and sworn in. They give evidence really only in cross-examination. Their witness evidence is submitted by their witness statements, and the judge should have read that. And they don't get a chance to give their evidence in chief before being cross-examined. In a way, that speeds things up, obviously. But in a way, it's a shame, because you get no chance to see what the witness is like when he's not, or she is not being roughed up by the other side. So the witness is always going to look a little bit dodgy and shifty, because that's what the other side are going to try and make them look like. And the judge never sees them in sense as they are. And that's one of the slight shortcomings of modern litigation. And you just have to be ready for it. But your witnesses are not always as wonderful as you might think. But you hope then that the other side of the witnesses are going to just face the same difficulties, and that will balance itself out. You guys, the charity legislators, are unlikely to get into the witness box, one would hope. It seems pretty unlikely that will happen. I've known it to happen, but that tends to be professional negligence claims in where an estate's been involved. And they may have to go to the witness box for that. But that's a pretty rare thing, and you'll be warned well in advance of that. So witnesses they're taking their witness statements. They're asked if they signed it. They're asked if it's true. One hopes they say yes. It has been known to say, I've never seen this document before, or that's not my signature. Oh God, we don't need that sort of trouble. So then you get stuck into cross-examination. And if can you show us the next photo, next slide? That was a litigant who I had to cross-examine over a forged will case some years ago. And that was her coming to court the day I was going to cross-examine her. And then we have a next slide, which shows her leaving court at the end of the day after she's been cross-examined by me all day. And you can see the toll that it takes on the poor person. It's not a nice experience, I think, to be cross-examined. It's a rigged game by and large, and she came out of it, I'm afraid, rather badly. And the judge took the view that the will under which she was the sole beneficiary had been forged. So that is what you hope happens to the other side. It's what you definitely hope doesn't happen to you. What are the next slide, just to get away from this one, that actually is an equally ominous slide, because that was Mrs. Gill in RSPCA and Gill. And that's the look on her face when she's come out having won the case. So you don't always manage to cross-examine the life out of it. She was actually cross-examined extremely well. And I didn't do the case, but I read through the transcript afterwards, and huge headway was made in cross-examination against her, but she still somehow won that case. Extraordinary case, and it's a good example for charities to know that just because you've got a very strong case doesn't mean you'll win it. There was a very good offer was made to her beforehand. She wouldn't take that, and she won it on undue influence at the trial, which was a very unusual result, and really insupportable, because the mother was supposedly undue influence by her husband, who then died 7 years before the mother died. Well, she had 7 years to write a new will, never had. So undue influence surely must have been wrong. And the Court of Appeal didn't support it on undue influence, they supported it on want of knowledge and approval. Again, an extraordinary result. So, because the will had been read over to her a couple of times, she knew what she was signing, big. So just a fine example of just how difficult these can get. What else do we have on that thing? We expert evidence as well as cross-examination. Expert evidence is rather different from normal factual evidence. It's a different type of jousting, but where you're trying to get one expert to come closer, the other side to come closer to your expert's view, trying to break down the gap between them in some way or other. The courts sometimes do that by hot tubbing, they call it. It sounds like a bizarre name, but they put both the experts in the witness box at the same time. They don't then fill it up with bubbling water and give them a glass of Prosecco each, sadly. That would normally sort it out much quicker. But they put them, they sometimes put both the experts in the witness box, and so each question can be answered by each expert, just one after the other. I'm not so sure it's a great idea, but some judges quite like it. When we got through the cross-examination, when we've had the experts give their expert evidence, closing submissions, normally a day's break before you get the closing submissions for everything to be marshalled and gotten in some kind of paper form too. And then you put your case before the judge. The other side try and rubbish it and put their case. And the judge tests each side and that can go on for a day or two, normally not much more than a day. That's normally the close of the trial. The judge won't normally give his judgment there and then. If it's the case that lasted more than a day, it's pretty rare for them to give a judgment straight away, which is sort of a surprise sometimes. Most of the clients come thinking, oh, well, we're going to, we'll get judgment today. It's here we are. This is the culmination of all these years. We will at least know, but you don't. And the judge instead, he won't tell you, he or she won't tell you how long it'll take either. Some of them, one or two of them will say, I'll do it by next Monday. But that's very, very rare. You may have seen in the press recently, some chap called Mr. Justice Sweeting had his knuckles rapped by some judicial body for taking 15 months to give his judgment. Obviously far too long, and yet, quite frankly, the Supreme Court and the Privy Council regularly take 10 months, 15 months to give their judgment. So it's just a disgrace, I'm afraid to say, but it can happen. So you don't know when you're going to get a judgment. You really don't know.
It's just a huge anticlimax, for clients, and for the lawyers as well. We invest in this as much as you do, and we work towards this day, 2 days, 3 weeks, whatever it needs to be at trial, and it can be exceptionally frustrating to reach that point with that uncertainty. I just wanted to touch on a couple of points, if I may, in terms of the solicitor's role in the trial, because whilst the barrister presents the case to the judge and deals with the cross-examination, the solicitor always sits behind them to support both you as clients and also the barrister as well. It's a team effort by that stage, and where you're taking notes, referring to points that are highly relevant to you, which Tom quite rightly says can sometimes be missed by the lawyers because we're focusing on some other aspect. What the solicitor should be doing during the trial is taking a full note and keeping records of those timestamps. So periodically just putting timestamps down on their handwritten note of what's happening. So if you've never been to a trial before, you are there and you've been asked to make any points, to note any points down. Don't panic if you don't get those timestamps or there's always somebody else there taking a note, and there will always be the transcript. And if it needs to be pored over to double check the point, it can be. And it's just important to make reference to the issue rather than anything else. But it's so helpful when you can have that genuine team working together to further the case. So that includes the client, that includes legacy officers, anybody who's there to represent the charity. That direct involvement will really help on the day, and likewise where support is needed from us, we can give that as usual. I presume, Tom, from your experience in terms of the closing submissions, by that stage, any of those notable points that the client might have written down or that your solicitor's written down, those are all collated, reviewed, considered, everything's in by that point. So there's always a chance to say something and to raise an issue up to the point of closing submissions so that it's dealt with. Is that your perspective?
Absolutely right. That's where you draw together all those best bits.
Yeah.
All those items which the judge himself may have missed the importance of. You can stress it and you can can work through them all. And I find that by then I've got almost a whole sheaf of the post-it notes,
right.
which on which notes have been written, which I've kept all of them, go through them when I'm preparing my closing submissions to make sure that nothing is mixed. And I'm afraid it's a terrible admission on my part, but I did a case once where the client was always slapping notes to me, always, and I found it it interrupted my flow a lot. And by the time I got about 17th or 18th, I rather started ignoring them. And about the 18th, in fact, I noticed after the hearing was the absolute killer point. And we didn't kill them at that hearing, but we killed them at the next one with that point. But once you made that mistake once in your life, you're not going to do it again. So you make sure you keep all those notes and go through them before the end of the trial. Make sure the judge has got everything that's been fed to you from your client and from your solicitor and team. Absolutely.
Yes. Great. I'll just whiz back through. We touched on judgment. Obviously, we touched on the fact that it can take weeks and weeks and weeks and potentially months. Yes, it may be given on the day, but really unlikely. The sorts of cases that are going to trials for charities, and particularly where it's a consideration of a point of law, they are not going to be done in a day, and so that is not a realistic eventuality, but it's there, it's possible. Likewise, we've just mentioned here that where there needs to be any specific orders made at the conclusion of the trial, for example, if certain provisions in relation to the estate need to continue, or there needs to be some specificity over how matters are to be dealt with pending the handing down of judgment, that may very well be dealt with, but they will be administrative issues rather than substantive decisions on the legal aspects.
But it can be very important, Eleanor, can't they? But if you've got a fraud or forgery case, for instance, you may have some kind of injunction leading up to trial, which stops at the end of trial. It may not stop at judgment, it may stop at trial. So you may need to have that section of that injunction carried through, or against perhaps other parties if it's been discovered within the trial that you need to bring them within the scope of some kind of injunction. So there are some things which you need to consider.
Yes, absolutely. A really important point, because if you are waiting months and months for a decision, a lot can happen during that time. So absolutely, really important to note that. And the lawyers, your legal team will be alive to those issues. There will be no need for those to sort of be discussed and dealt with later. We'll be ready to deal with them at trial, and the issues raised to the judge, so that order can be made, notwithstanding the judgment coming later on. So we've had our judgment. It is not good. We've fought hard. We've worked towards this. We really.
Eleanor, this is all Eleanor, this is going to be completely hypothetical, because of course, with you and I acting for the charity, then the decision is not going to go against them. But
well, of course,
it's as well to mention it, in hypothetically.
I know, absolutely. I mean, if there are other lawyers on the webinar today, it's more, this is just a hypothetical thing. We're talking about it notionally. Of course, it would never happen. But if it did, the decision has gone against you. I've talked through the doom and gloom right at the beginning to say that the charity must be considering adverse outcomes right at the beginning, and the economic impact of that. So that's costs, but also the impact on publicity. So the first box here is really obvious, but we've got to be prepared for a bad outcome. We've got to know that this is a possibility. We've got to work hard to achieve a successful outcome, but be ready to deal with what comes from it if that isn't the case. Those risks need to be considered early on. We've got to have that clear decision making, transparent, legal advice that's been given along the way, and justifiable decisions being made. If it goes against us, and there is a specific point of fact or law that isn't right, or that hasn't been dealt with properly by the judge, then it's possible to appeal it. And I think looking at the next month's webinar, dealing with issues after a trial, that will be dealt with in more detail. But it is possible. If the decision at first instance goes against you, there is a route of appeal if it's right to do so, and that is something that the lawyers will be ready to advise you on the second the judgment comes in, and all those options can be discussed. Otherwise, it's okay, it's not appealable for whatever reason, or even if it is, you've still got to deal with the cost aspect. Funding adverse costs orders, we talked about this earlier on. We have to have made sure that we've conducted ourselves reasonably, we've been transparent, we've done proper decision making, so that the judge doesn't see fit to penalise us even more, other than just as being a losing party. But real thought needs to be given as to how this will be funded. It's a short timescale, as Tom said earlier. It's less than a month. That could be, hundreds of thousands of pounds to be found and paid. So that is part of the preparation. That should be identified and a plan made before the trial begins. Otherwise, in terms of publicity, obviously we don't want our supporters to be put off by these negative outcomes. We don't want the publicity to be generated to such a degree that we're not able to respond to it, or we respond to it in an unsatisfactory way. So we get public relations support retained. We've got somebody who is on the case and is aware of it. They're ready to go. We've got press releases drafted. There are, all manner of things that can be done in advance, and that is a really important step. Looking now at the last couple of boxes, damage limitation and reflection. I mean, damage limitation, you would hope that your PR support can help you with that publicly, but what about internally? Have decisions been made that shouldn't have been made? Is there, something that needs to be considered in terms of the charity's governance, which protects the charity from this happening again? Are there those internal considerations which need to be undertaken in light of the decision? And even if there isn't, reflection, talking to your lawyers, understanding the reason why things didn't go your way, and making sure that there is a clear understanding of what that was, so that the next time something like this occurs, there is precedent there to help you make decisions perhaps in a different way. You may say, we would have still done it. This was the right thing to do. We had legal advice. This was a point of law that we wanted the courts to consider, because it has a wider impact, as in Radcliffe, as in Islet and Mitson. But it just didn't go our way. Either way, it's just important to have that time of reflection and consideration of whether or not things could have been different.
Very true, Eleanor. Very true. But if I could just mention a bit about
yes.
that, the publicity side of things. In reality, no matter how bad the publicity is, it tends to die down. Memories tend to fade. Other things come before the public, so things are never quite as serious as they seem at the time. But a court case will generate publicity, and even if you're entirely in the right, it may generate adverse publicity. There was a case the RSPCA did in Hong Kong some years ago, where the will left them the entire estate, and the widow didn't like it. And she turned up for court every day in a wheelchair. There was nothing wrong with it at all. But she would make her entrance in the wheelchair every day, and it looked awful that this poor person, vulnerable person in a wheelchair, what can you do? You can't tip her over and prove that she can walk. So you will be faced with these trials and tribulations, uphill and down dale. And even if you win, and you're vindicated. I had a case where a maritime charity was left an awful lot of money. And I said to my solicitor, it's unusual for a client making a will to choose that charity. Was there any particular connection? He said, well, they left the estate prior to that to the RNLI, but they'd seen a huge legacy go to the RNLI in the paper and thought, oh, well, the RNLI won't be so impressed with mine anymore, so that I'll give it to somewhere where it's going to be more valued. So even if you win, you can't account for the effect of publicity always. It's something you need broad shoulders, effectively.
Yeah, absolutely. You really cannot win in those circumstances. I put through this slide just to talk about the key sort of messages before we close things off. It's about preparation. It's about looking at the risks and giving very careful thought and consideration to the dispute, to the economic impact of the dispute. When we look at litigation commenced by individuals, we see so often the phrase, but it's about the principle. It's about doing the right thing. That is a freedom that only the individuals have in these cases, where they can pursue a claim or a defence based on the need to prove some moral right. And the charities do not have that luxury. It has to be so very carefully thought through, and adverse outcomes aren't just a matter of the losing judgment. The impact on the charity's funds and publicity always need to be taken into account. That said, there are unavoidable circumstances where a case must be pursued for a point of principle, but it's because the considerations have been taken into account, and the impact of that point of principle goes much wider than any individual charity. In terms of how the case sort of concludes, obviously we've talked through the worst case scenarios, we've talked through the risks of costs and adverse costs, but the proper functioning of the charity is really the sort of consistent message throughout. So it's about internal governance and keeping very clear records of decisions, and having those transparent discussions between the trustees that are then recorded, so that they can be referred back to. And it's very easy for us to sort of say this in a taking a step back, but I've put on the next slide a link to the Charity Commission guidance that I talked about right at the beginning, but that also has some useful, quite general points in terms of governance and how these issues can be managed and mitigated. So I'd encourage anybody who hasn't seen it and read it to go and have a look at it, and the link is there. It will be available to click through when you get the electronic copies of the slides. And I've also put the link over to the IDR network there, because I've seen a couple of questions come in that relate to the previous webinar. The September webinar is on the IDRN. I believe it will also be on Radcliffe Chambers' YouTube channel as well. So two places to go for that to review. And likewise, this will be on there, and next month's webinar, which is on the 22nd of November. I hadn't seen any other questions come through, but to close things off, we've got a little bit of time. If anybody does want to raise any questions, you're very welcome to. We will happily go through them, but equally, if you want to send us emails afterwards, then you can do. The notes will be circulated to attendees, and our contact details will be on there, so feel free to send anything through to us. I'll just check the time.
Eleanor, can I mention one thing that might be worth considering throwing into the mix? I know we're in court now, so it's all a bit late, but there's always a possibility of getting as it were, an audit check on the advice you're getting. If you are really heading for a huge trial with an awful lot of expense, is it worth just checking that with another lawyer who's got nothing to gain by the taking the case to court? Is it just who might stand back and look at it in a way that a judge might do? Is that something that's worth considering? I was involved once by a charity that was thinking of taking a libel case, oddly enough, and they had very, very bullish advice from the libel lawyers that they would win this case, and it would be a thumping great win, and no doubt about it. And I had to say, well, you may be right, but I'm not even sure you're entitled to spend your money pursuing libel cases as a charity. That needs to be given clear thought, and nor am I quite so sure that just because you've got a bullish advice from a libel lawyer, you're necessarily going to win. That you've got to be careful about these things. So that is a possibility. Because there's no end to that. A lawyer saying, "Oh, take more legal advice," sounds like it's almost the worst thing that could happen. But it's something that you might think about if you are feel you're going inexorably towards the train crash.
Absolutely, and particularly if there are those very early considerations as to standing as well. Are you even able to bring this claim? Let's talk about that before we talk about prospects of success, because that's your direct route to a costs order if you mess around with things like that. So I think it is really important, all of those considerations. It can feel overcautious, a very conservative approach, but the role of a charity is to protect and secure the trust funds, and to make sure that they are working towards a specified purpose. And those duties and responsibilities mean that there are higher considerations and higher levels of thought that needs to go into these decision makings. It cannot be an off the cuff point of principle that somebody's just feeling perturbed by. So I think that, thank you so much, Tom, for all your insights. It's so important to hear these real life perceptions, because even now I see a real reduction in the amount of trials, compared to 5 or 10 years ago. Things are different. The trial doesn't come around as much. The sort of ADR mediation is so popular and so well serviced now as an option. It tends to be the resolution tends to be earlier. So for those going to a trial, or getting to the point of trial and having to attend, I think this will have been a useful run through about what to expect, who's there to support you, why you might be there in the first place, and what to do if things go wrong. So thank you so much for your input, Tom. It's been brilliant. And thank you to everybody for joining us today. We really do appreciate the attendance, and if there are any questions, please do follow up with us afterwards. There isn't anything that's come through on the Q&A, but I wish you all a good afternoon, and thanks again for joining us.